A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. In this video, we will explain what estate taxes are and provide strategies to minimize them for 2024. Estate taxes are levied on the transfer of property upon the death of the owner. They are calculated based on the total value of the deceased person's estate, including cash, real estate, stocks, bonds, and other valuable assets. Understanding these taxes is crucial for effective estate planning, as they can significantly reduce the amount your beneficiaries receive. The federal estate tax is imposed by the IRS. As of 2024, the federal estate tax exemption is $12.92 million per individual. This means that if your estate is valued below this threshold, it will not be subject to federal estate taxes. For estates exceeding this amount, the tax rate can be as high as 40%. State estate taxes vary significantly from federal estate taxes. Several states impose their own estate taxes with different exemption limits and rates. For example, New York has an estate tax exemption of $6.58 million with a top tax rate of 16%, while California does not impose a state estate tax at all. It is essential to understand the specific laws in your state to effectively plan and minimize your estate tax liabilities. There are several strategies to minimize estate taxes. One common method is gifting. The IRS allows individuals to gift up to $17,000 per person per year without incurring gift tax. By gifting assets to your heirs while you are still alive, you can reduce the overall value of your estate. Charitable donations are another effective strategy. Donations to qualified charities are deductible from your estate, reducing the taxable amount. Establishing charitable trusts, such as a charitable remainder trust or charitable laid trust, can provide you with income during your lifetime and reduce estate taxes. Trusts are also valuable tools for managing and reducing estate taxes. Irrevocable trusts, for example, remove assets from your estate, thus lowering the estate's value and potential tax liability. Special needs trusts can ensure that beneficiaries with special needs are provided for without disqualifying them from government benefits. Life insurance can be a useful tool in estate planning as well. By setting up an irrevocable life insurance trust, the proceeds from your life insurance policy can be excluded from your taxable estate, providing liquidity to pay estate taxes without depleting other assets. Family limited partnerships allow you to transfer assets to family members at a discounted value, reducing the overall value of your estate and providing tax benefits. Let's look at some real-life examples. The Smith family, with an estate valued at $20 million, reduced their estate by $1.7 million over 10 years by gifting $17,000 annually to each of their 3 children and 7 grandchildren, significantly lowering their estate tax liability. In summary, understanding estate taxes and implementing effective strategies can significantly reduce the tax burden on your estate. Whether through gifting, charitable donations, trusts, life insurance, or family limited partnerships, there are numerous ways to minimize estate taxes and preserve your wealth for future generations. If you need assistance with estate planning, consider consulting with an experienced estate tax attorney. They can provide personalized advice and strategies to meet your specific needs. Thank you for watching. If you found this video helpful, please subscribe to our channel for more informative content on estate planning and related topics.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The Franchise Agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones.
A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the Special Needs Trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a Special Needs Trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Many seniors enjoy the opportunity to be generous to their children by gifting them monetarily. In certain circumstances, however, there is a real concern that people who may be in need of long-term nursing care in the near future should not give gifts. It can be complicated trying to adequately plan for long-term care and consider gifting. In Wisconsin, for Medicaid to cover the huge expense of nursing home care, seniors must show that they own nothing more than around $2,000, and they must also show that they have not given away money or assets over the prior 5 years. The look-back period, or the transfer penalty, would charge that senior for their generosity. Depending on the size and number of the gifts, the penalty could be substantial. Many wrongly think that there is no penalty for gifts of up to around $15,000 annually. That misunderstanding confuses tax law with Medicaid law. The Medicaid rules are entirely different from the tax rules. In the Medicaid context, gifts of any amount that are given during the look-back period can be penalized. There are exceptions, including gifts to spouses and siblings under certain circumstances, disabled children, and children who are caregivers and who live at home with the elder for a span of time. But overall, gifts and Medicaid do not belong together. The Medicaid rules are complicated, and the consequences for mistakes can be very costly. There are a number of options to protect assets and still qualify for benefits, but these options must be weighed with great care. This is why it's best to consult attorneys who are experts in Medicaid law. Contact Heritage Law Office today for more information on long-term care planning, Medicaid, and gifting. In this video, we will explain what estate taxes are and provide strategies to minimize them for 2024. Estate taxes are levied on the transfer of property upon the death of the owner. They are calculated based on the total value of the deceased person's estate, including cash, real estate, stocks, bonds, and other valuable assets. Understanding these taxes is crucial for effective estate planning, as they can significantly reduce the amount your beneficiaries receive. The federal estate tax is imposed by the IRS. As of 2024, the federal estate tax exemption is $12.92 million per individual. This means that if your estate is valued below this threshold, it will not be subject to federal estate taxes. For estates exceeding this amount, the tax rate can be as high as 40%. State estate taxes vary significantly from federal estate taxes. Several states impose their own estate taxes with different exemption limits and rates. For example, New York has an estate tax exemption of $6.58 million with a top tax rate of 16%, while California does not impose a state estate tax at all. It is essential to understand the specific laws in your state to effectively plan and minimize your estate tax liabilities. There are several strategies to minimize estate taxes. One common method is gifting. The IRS allows individuals to gift up to $17,000 per person per year without incurring gift tax. By gifting assets to your heirs while you are still alive, you can reduce the overall value of your estate. Charitable donations are another effective strategy. Donations to qualified charities are deductible from your estate, reducing the taxable amount. Establishing charitable trusts, such as a charitable remainder trust or charitable lead trust, can provide you with income during your lifetime and reduce estate taxes. Trusts are also valuable tools for managing and reducing estate taxes. Irrevocable trusts, for example, remove assets from your estate, thus lowering the estate's value and potential tax liability. Special needs trusts can ensure that beneficiaries with special needs are provided for without disqualifying them from government benefits. Life insurance can be a useful tool in estate planning as well. By setting up an irrevocable life insurance trust, the proceeds from your life insurance policy can be excluded from your taxable estate, providing liquidity to pay estate taxes without depleting other assets. Family limited partnerships allow you to transfer assets to family members at a discounted value, reducing the overall value of your estate and providing tax benefits. Let's look at some real-life examples. The Smith family, with an estate valued at $20 million, reduced their estate by $1.7 million over 10 years by gifting $17,000 annually to each of their 3 children and 7 grandchildren, significantly lowering their estate tax liability. In summary, understanding estate taxes and implementing effective strategies can significantly reduce the tax burden on your estate. Whether through gifting, charitable donations, trusts, life insurance, or family limited partnerships, there are numerous ways to minimize estate taxes and preserve your wealth for future generations. If you need assistance with estate planning, consider consulting with an experienced estate tax attorney. They can provide personalized advice and strategies to meet your specific needs. Thank you for watching. If you found this video helpful, please subscribe to our channel for more informative content on estate planning and related topics. Is it better to use joint ownership or a trust to pass down a home? You may be wondering about how to pass your home to your spouse, children, or other beneficiaries after you die. A will works, but that will require them to go through the probate process, which may take a considerable amount of time and money. There are estate plan alternatives that allow the bypass of the probate process to ensure a faster, easier transition that will also be less expensive for the beneficiary. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive, and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. Contact Heritage Law Office today for a free case evaluation.
The role of life insurance in succession planning. Welcome back to our series on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Life insurance can play a critical role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of your business for the future. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you. In this video, we will explore the essential differences between trusts and wills and answer some common questions to help you understand these important estate planning tools. A will is a legal document that outlines how your assets will be distributed after your death. It must go through the probate process, which can be time-consuming and public. A trust, on the other hand, is a legal arrangement where one party holds and manages assets on behalf of another. Trusts can often avoid probate, providing a quicker and more private way to distribute assets. So, do you need both a will and a trust? The answer depends on your unique circumstances. Wills are crucial for naming guardians for minor children and specifying final arrangements. Trusts, however, can manage and distribute assets efficiently and provide benefits during your lifetime, especially if you become incapacitated. Having both can ensure comprehensive coverage for your estate. Now let's look at the different types of trusts and their benefits. Revocable trusts or living trusts can be altered during your lifetime and help avoid probate. Irrevocable trusts, which cannot be changed once established, offer asset protection and tax benefits. Charitable trusts support philanthropic goals and provide tax deductions. Testamentary trusts are created through a will and take effect upon your death. Special needs trusts ensure care for a beneficiary with special needs without affecting government benefits. Medicaid asset protection trusts help protect assets for Medicaid eligibility. Trusts can also be an effective tool for minimizing estate taxes. Irrevocable trusts, for instance, remove assets from your taxable estate, potentially reducing your estate tax burden. Charitable trusts can provide both estate tax benefits and charitable deductions. Specialized trusts like grantor retained annuity trusts, or GRATs, and qualified personal residence trusts, or QPRTs, can also help reduce estate taxes. However, not all assets can be placed in a trust. Retirement accounts like IRAs and 401ks typically cannot be transferred into a trust without triggering taxes. Your primary residence can be transferred into a trust, but it requires careful planning to avoid losing homestead exemptions. While vehicles can be placed in a trust, it can be complex and might not be necessary. Choosing the right trustee or executor is crucial for the smooth administration of your estate. Look for someone trustworthy, with financial acumen, and who is available and willing to fulfill their duties. Impartiality is also important, especially in families where potential conflicts may arise. Professional or corporate trustees are an option if you do not have a suitable individual in mind. It's also essential to regularly update your will or trust. Major life events like marriage, divorce, the birth or adoption of a child, significant financial changes, or moving to a different state can impact your estate plan. Regular reviews with your attorney can ensure your documents remain up to date and effective. Understanding the differences between wills and trusts and knowing when to use each is vital for effective estate planning. Trusts and wills can work together to provide a comprehensive plan that addresses all your needs. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you in the next.
Are you unsure whether a will or a trust is the best choice for your estate planning? In this video, we'll explore the key differences between wills and trusts to help you make an informed decision. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It can include instructions for distributing personal property, naming guardians for minor children, and specifying funeral arrangements. One of the main advantages of a will is its simplicity and ease of creation. However, it's important to note that wills must go through the probate process, which can be time-consuming and public. Next, we have trusts. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of beneficiaries. There are two main types of trusts: revocable and irrevocable. A revocable trust can be altered or dissolved by the grantor during their lifetime, offering flexibility and control. An irrevocable trust, on the other hand, cannot be easily altered once established, providing greater asset protection and tax benefits. Trusts generally bypass the probate process, offering privacy and potentially faster distribution of assets. When comparing wills and trusts, there are several factors to consider. Cost is one aspect. While wills are generally less expensive to create, trusts can save money in the long run by avoiding probate fees. Flexibility and control also vary, with wills being easier to amend, but trusts offering more control over asset distribution during your lifetime and after. Privacy is another significant difference. Wills become public record through probate, whereas trusts remain private. Additionally, the management and distribution of assets can be more streamlined with trusts, especially for complex estates. So, how do you choose the right option? Here are some questions to help you decide. What are your estate planning goals? If your primary goal is to ensure your assets are distributed quickly and privately, a trust may be the right choice. How do you feel about the probate process? Trusts can help your beneficiaries avoid the time-consuming and often costly probate process. Do you have minor children or dependents with special needs? Trusts can offer more control over how and when your assets are distributed, ensuring your children or dependents are cared for according to your wishes. What is the size and complexity of your estate? Larger estates might benefit more from the flexibility and control that a trust provides. Are you concerned about privacy? Trusts do not become public record like wills during the probate process. In conclusion, both wills and trusts have their unique advantages and can be tailored to meet your specific needs. It's always wise to seek professional legal advice to make an informed decision. For every estate plan, it is important to start by considering your objectives. That is the first step in determining what assets should be in your trust. Oftentimes, it is easier to start by thinking about what you should not put into your revocable living trust. If a revocable living trust has the distribution set up correctly and how you desire, a revocable living trust may be appropriate for holding the bulk of your assets, with some important exceptions. Before we get into those exceptions, it is important to understand how trusts work so that we understand why those exceptions apply. Think of trusts as a different entity, the same way that an LLC or a corporation is a different entity from its shareholders. A trust is a different legal entity from the trust creator. Trusts are capable of acting independently, owning assets independently, filing lawsuits, and being sued themselves. It is because of these functions that we need to be cautious when it comes to transferring qualified assets, such as an IRA or 401k, to a revocable trust. The transfer of an IRA or 401k to a trust is similar to transferring it to a different owner, such as a different person, a different corporation, a different entity, and in doing so, the IRS considers this a taxable distribution. Similar to qualified assets, when a health savings account and medical savings account are transferred to a trust, they may be subject to taxes. Additionally, transferring a vehicle to a trust may result in the need to pay title transfer fees and additional taxes for issuing the new title. This list is not exhaustive. Other than the above-mentioned items, a revocable living trust may be a good option for the majority of your assets. This means your bank account, your house, your post-tax investment account, etc., should likely be transferred to a trust. You should pay special attention to retitling your assets to a trust to avoid unwanted taxes or other consequences. Contact one of our attorneys to make sure your assets are properly protected. In this video, we will discuss setting up a trust, the different types available, their benefits, and how you can get started. A trust is a legal arrangement where one party, the trustee, holds and manages assets for the benefit of another party, the beneficiary. The person who creates the trust, known as the grantor, transfers their assets into the trust, which are then managed according to the terms set forth in the trust document. Let's dive into the types of trusts you can set up. First, we have revocable trusts. These allow the grantor to retain control over the assets and make changes to the trust as needed. They are flexible and can be altered or revoked entirely during the grantor's lifetime. However, they do not offer protection from creditors and are included in the grantor's estate for tax purposes. Next, irrevocable trusts. These cannot be modified or terminated without the permission of the beneficiaries once established. They offer strong asset protection and potential tax benefits, but less flexibility since the grantor loses control over the assets. Charitable trusts are designed to benefit a specific charity or the public. They provide significant tax benefits to the grantor and can offer income to the grantor or beneficiaries. A special needs trust provides for a disabled beneficiary without disqualifying them from government assistance programs like Medicaid or SSI. It preserves eligibility for public benefits while providing for the beneficiary's supplemental needs. Finally, spendthrift trusts protect the trust assets from being claimed by creditors of the beneficiary and help manage the distribution to prevent reckless spending by the beneficiary. Now, let's talk about the benefits of setting up a trust. Trusts can help you avoid probate, saving time and reducing legal costs. They offer privacy since they are private documents and do not become part of the public record. Certain trusts can protect assets from creditors and lawsuits. They also provide tax advantages, potentially reducing estate and gift taxes. Trusts allow detailed instructions on how and when assets are distributed to beneficiaries and offer flexibility to change terms as circumstances evolve. Setting up a trust involves several key steps. First, determine your goals. Identify your primary objectives, such as avoiding probate, protecting assets, or supporting a charitable cause. This will help you choose the type of trust that best suits your needs. Next, choose the type of trust based on your goals. Consult with an experienced attorney to understand the advantages and disadvantages of each type. Draft the trust document with an attorney, outlining the terms, including the trustee's responsibilities, the beneficiaries, and the distribution of assets. Fund the trust by transferring the chosen assets into it. This step is crucial as the trust will not be effective until properly funded. Appoint a trustworthy and reliable individual or institution as the trustee. The trustee will be responsible for administering the trust according to its terms. Sign and notarize the trust document to make it legally binding. Depending on state laws, notarization may be required. Update beneficiary designations to ensure all beneficiary designations on accounts, insurance policies, and other assets align with the trust. Finally, inform your beneficiaries about the existence of the trust and its general terms. While you may not need to share specific details, it's helpful for them to understand their roles and what to expect in the future. To recap, trusts offer numerous benefits, including avoiding probate, providing privacy, protecting assets, offering tax advantages, and giving you control over asset distribution. Setting up a trust involves several steps, from determining your goals to informing your beneficiaries. Thank you for watching. If you found this video helpful, please like and subscribe for more. Many people ask, should you put your house in a trust? The answer is probably yes, and in certain situations, the answer is a resounding yes. One of the wonderful things about revocable living trusts is there are very few downsides. If you are not familiar with a revocable living trust, think of a trust as a bucket. The bucket can hold your assets and contain a set of rules and instructions for what happens with the assets upon your passing. In that respect, the trust can function like a will in that it passes your assets to your beneficiaries. However, a revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate.
Let's talk about choosing the right business structure. The most common structures are sole proprietorship. Right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure